Welcome to In the Name of the Law with your host, Lisa Speaker from Speaker Law Firm. Joining her today is Stephen Sinas from Sinas Dramis Law Firm, along with Mary Chartier and Takura Nyamfukudza from Chartier Nyamfukudza PLC. Now let's discuss some remarkable stories and real cases.
Welcome to In the Name of the Law, a legal talk show about real people and real cases. Today we're going to talk about the First Amendment in criminal cases, how the initial custody proceedings begin before the friend of the court, and pedestrian motor vehicle accidents. Stay tuned.
In the name of family law.
Today we're going to talk about domestic abuse and family law cases. I have with me attorney Lisa Schmidt. She is an attorney at the Speaker Law Firm, but before that she had her own family law firm in Ferndale, Michigan for 10 years. Welcome, Lisa.
Thank you for having me.
So let's start off because I hear different terms and I want to understand why there's a difference. I hear the terms domestic violence and domestic abuse. What is the difference and when do we use them?
Sure. So domestic violence is a specific legal term which actually has two different meanings. So there's the criminal domestic violence, which is a form of assault between people who have a relationship together, might be cohabitants in a home, things like that. The same term, domestic violence, also appears when talking about child custody, but in that sense, we're talking about a broader picture. So we've got a case from a couple of years back, 2020, that says that domestic violence means more than just physical harm. It also includes the intent to cause mental harm, to threaten. In that case, there were questions about corporal punishment, meaning spanking, and also abuse of the family's dog. So we get a broader spectrum when we're talking about it in the family law setting than in the criminal law setting, where you basically need a physical act. Domestic abuse is not necessarily directly referenced in child custody, but it is used in divorce cases. Domestic abuse shows up when we're talking about property division between spouses or spousal support issues. And domestic abuse, again, is broader even than the definition of domestic violence for the Child Custody Act.
So how is domestic abuse showing up in family law cases? Let's talk about what it looks like.
Sure. So domestic abuse can take many different forms. So there's something that has been produced by psychologists and social workers called the power and control wheel. And this power and control wheel talks about various different forms of domestic abuse that are not just physical. So when you look at the power and control wheel, we see that the physical violence is outside because that's the most severe form. But within that spectrum, we also see things like coercive control, control over the finances, isolation of the person from their friends and family members, trying to use the children against the victim of this or the survivor of domestic violence and abuse. So it's much more of a holistic pattern of control and an assertion of dominance within the relationship.
Okay, so what do we do with a situation where it just seems like in every family law case, somebody is claiming that there's domestic abuse? And what do we do with the situation where there's an allegation and it's just being used to get some leverage in the case?
So first of all, I want to point out that when studied, only about 2 to 5% of domestic violence reports are absolutely false. Right? False reporting is very, very minimal. Usually when there is a report, something is happening. Now, what we do see in cases is that a spouse might say that somebody has a very bad temper or gets angry easily or has a tendency to yell, and that will get escalated. It will get blown out of proportion as things happen in the adversarial high conflict divorce situation. What we also see in some cases is that when there has been a pattern of dominance and control, one of the trauma responses that the survivor will experience is a defensiveness. They will become more defensive, and in doing so, they will become more aggressive. They will start to yell back. They may even strike back. then the abuser is more willing to report than the survivor. So the abuser calls 911 and the survivor gets charged with domestic violence for the one time they fought back. So sometimes we see this report flip-flopped.
I've definitely seen that.
Where unfortunately it's the person who historically has been in power who gets to take advantage of this police report or this domestic violence charge.
Or doing whatever they can to make the other person look like they're mentally unhinged or...
Yes. And this is another thing that comes up a lot because one of abusers' tactics is to belittle or demean the other party. And so a lot of times they'll say, oh, and I should say that more of these cases involve a male abuser against a female survivor, not all of them. I have seen cases with a female abuser against a male survivor. I have seen cases in same-sex couples where we have an abuser and a survivor. However, a lot of the documentation about this is still written with the male abuser because it is a higher prevalence. So in a case like you were just talking about, you might have a situation where the abuser says, oh, she's crazy. She exaggerates, she gets emotional, and does a lot of this demeaning behavior, playing on a lot of sexual stereotypes from years back of like histrionics and so forth. So when that happens, it is actually an abuse tactic. Don't take her seriously. Don't take him seriously. They're blowing it out of proportion. They're making up things that didn't really happen.
So I wanted to talk about how the trial judges are viewing these claims of domestic abuse or domestic violence. And I was going to tell you that I feel like I've seen so many cases where a judge doesn't really believe the survivor has been abused unless there's like a physical assault, like physical evidence that they've been injured. And honestly, a light bulb went off when you were talking earlier because it just dawned on me that so many of our family law judges were former prosecutors. And they're thinking about the very first definition of domestic violence, which does require that physical contact. Yes. And not the broader definition which we see in the family law context. So, but I want you to share, if you can, how are the judges looking at these cases?
So you're exactly right. There are some judges in the state who still try to be very restrictive. They want to see a police report. They want to see a criminal charge. When they don't see these things, they
or an eyewitness.
Or an eyewitness.
Right.
And a lot of times, domestic abuse happens behind closed doors. And in fact, abusers are often very skilled at having one face in public and another in private. And this can cause problems in the courthouse because, as we all know, he said, she said is very hard to prove anything. And so when the person who has performed the abuse sits and testifies and is very put together and is very rational and is very calm on the stand, and then the survivor gets up there and tells their story and becomes emotional and gets upset and maybe can't remember details and maybe confuses timelines, all of which are psychological trauma responses. It's what your brain does chemically. When that happens, it is easy for a judge to believe the calm, rational one on the stand rather than the person who is reacting to a very real psychological processing challenge. And so this is why it's really important, if you are a survivor of domestic violence, that you work with someone who is trauma-informed themselves, somebody who
work with an attorney.
With an attorney, okay. And or a victim advocate. So there are resources across the state for survivors of domestic violence where they can receive victim advocates, sometimes for free, that can speak on their behalf in certain circumstances, can help facilitate things like finding replacement housing or connecting you with social workers or therapists to help you process what you've experienced. All of the things that happen outside of the courtroom that can help you be a more effective witness when you actually do get on the stand. And you should definitely have an attorney who is trauma-informed, because a trauma-informed attorney, and this means someone who has taken specific training about domestic violence, they're the ones who are going to be able to most effectively make your case.
Great. Thank you, Lisa.
In the Name of Family Law is brought to you by Speaker Law Firm. in the name of personal injury law.
Today I have with me Steve Sinas, a personal injury attorney at the Sinas Dramis Law Firm, and we're going to talk about motor vehicle crashes with pedestrians. Thank you, Steve, for coming on, and I hope you can answer some questions for us about those pedestrian accidents.
Thanks for having me.
So, how often are pedestrians in Michigan injured by auto accidents?
So according to the Michigan State Police, over the last 20 years, there have been 20,000 crashes involving pedestrians. And over 80% of the time, the pedestrian is either seriously injured or killed. So this is a real serious issue. Over 100 pedestrians are killed each year in Michigan. So there are a lot of things to keep in mind when it comes to being a pedestrian, your safety and your rights.
Can a pedestrian receive Michigan no-fault benefits even if they don't have their own insurance?
Yes. So if you are walking down the road as a pedestrian and you're hit by a motor vehicle, which by the way does not include a motorcycle, but if it's a car, an SUV, a truck, you're going to be entitled to no-fault benefits. There can be some exceptions, but in general you should assume that you have some rights to pursue there. No-fault benefits include coverage for your medical expenses, your income loss, also some household services. So it's a really important right, but you can recover these benefits.
What damages can Michigan pedestrians recover from the at-fault driver?
The first place to start is whether the person has no-fault insurance coverage. If they do, you then need to determine how much coverage they have for their medical expenses. If on the no-fault side of things, they're covered for life, they're probably not going to have what we call an excess medical expense claim to pursue against the at-fault driver. But if they have less than lifetime coverage or no-fault coverage, they can pursue their uncovered medical expenses from the at-fault driver. So one of the rights can include your medical expenses. The other one is your income loss that's not covered by no-fault insurance. So you look at how much no-fault insurance is covering, and if that coverage expires after 3 years and the person still has a disability, they can pursue their uncovered excess income loss from the at-fault driver. In addition to that, they can recover pain and suffering damages if they satisfy certain rules where they're making a claim against the at-fault driver for compensation for their loss of quality of life, their pain and suffering, and it's a way of imperfectly compensating somebody for the impact their injuries have had on their life.
How do you determine negligence in a Michigan pedestrian case?
Negligence is a concept where we're asking whether the parties involved used reasonable care at the time the incident occurred. So when you're considering the at-fault driver, you're asking, did that driver use reasonable care in operating the motor vehicle? Part of that is whether the driver violated the Michigan Motor Vehicle Code. So you look at what the rules of the road are, so to speak, and see if the driver violated any of those rules. You then also look at the circumstances of how the crash occurred and any other facts and issues that could affect whether or not that driver could have said to have been using reasonable care or not. At the same time, you also have to look at the conduct of the pedestrian. Was the pedestrian comparatively negligent is the question that the law asks juries to consider, meaning did the pedestrian somehow contribute to the crash? Was the pedestrian walking out in a roadway where there wasn't a crosswalk? Did the pedestrian jump out in front of the car? Was the pedestrian not looking? There are all kinds of issues you have to examine in terms of how the pedestrian was behaving to determine who has fault and who doesn't.
What about the rights of pedestrians who are injured in a hit-and-run accident?
Pedestrians injured in a hit-and-run accident have the same rights as any other pedestrian, but the reality is that they have a harder time pursuing those rights because they don't know who hit them. And if you can't identify the driver, you don't know who to sue. And so if you have a truly unidentified hit-and-run driver, it's going to come back to whether the pedestrian has uninsured or underinsured motorist coverage in their own auto policy that's in their household that would cover them for any damages they could have had against the at-fault driver, because that's what uninsured and underinsured motorist coverage does. It kicks in if the driver doesn't have insurance or can't be identified. But if you're going to pursue one of those claims, there are some strict timelines you have to follow on hit and run uninsured and underinsured claims. So you really have to act quickly, and in those situations, getting a lawyer right away would be advisable.
Can the injured pedestrian recover uninsured and underinsured benefits?
An injured pedestrian may have the right to pursue uninsured and underinsured motorist coverage. It's going to depend on their auto insurance policy, whether it provides coverage for the facts and circumstances of where they were injured. There can also be the issue of a person living in a household where there's a policy, but it's not issued to them. And the question is whether the policy actually covers them as well, even though it's issued to some other relative or someone else they're living with. So the right can be there, but it's going to depend on the facts and details and the insurance coverage available to the injured person.
So I know that the Sinas Dramis Law Firm is very passionate about helping educate people to keep them safe. What resources are there out there to educate people, to tips to keep them safe when they're pedestrians?
Yeah, well, Michigan.gov has got some really good common sense pointers for pedestrians. So that's a good resource to turn to. As far as just general guidance, pedestrians have to understand that they have obligations to follow the law as well as motorists do. Everyone's got to follow the law. So when you are walking as a pedestrian, consider whether you're walking on the correct side of the road. Obviously, be looking out for motor vehicles when you're crossing the road. And you want to make sure you're not distracted too. We have a lot of cases where people are walking, looking at their phone, you have their AirPods in, and they don't see the motor vehicle that they're walking in front of. So you have to remain vigilant as a pedestrian. And as a motorist, you have to understand that there are many rights that pedestrians have to walk in certain places where you might be driving, where you might take a right-hand turn at an intersection. So everyone has to remain vigilant and follow the law.
Do you have any memorable pedestrian cases that you've worked on?
I had a case where a girl was crossing the road, not at a crosswalk. She had just picked up some food and was walking. The road was lit up with street lights. She had dark clothing, and a car came out of an apartment complex and hit her. And the driver of the car said that he thought that she was either a trash can or a mailbox and wasn't sure what he hit, so he kept on driving. And then we had to track him down, or actually the police tracked him down, and we were able to find his insurance coverage and we were able to make a recovery for the girl. But not only did we have the issue of the hit and run aspect, we also had them disputing that our client was the one who was at fault because she was crossing where there wasn't a crosswalk. And we argued that she was there to be seen and he wasn't paying attention. And we ultimately were able to get a settlement.
Now, earlier you mentioned something about if a pedestrian's hit by a motorcycle, that the rules are different. Can you briefly tell us what that's all about?
Yes. So when you are hit by a motorcycle is not considered to be a motor vehicle under the Michigan no-fault insurance law. So in that situation, there would be no motor vehicle involved. So you would not have the right to claim no-fault insurance benefits. Your rights would be governed by a negligence claim against the motorcyclist, assuming the motorcyclist was at fault. And you can, in that situation, pursue not just your pain and suffering, but also your medical expenses from the motorcyclist.
But if you are hit by a motorcycle in a hit and run, there's basically nothing for you?
If you're hit by a motorcyclist and it's a hit and run situation, it's going to depend on whether or not you have coverage that would cover you, like uninsured or underinsured motorist coverage for that type of crash. It's also going to be affected by whether or not you can find out who the motorcyclist is, and if you can, identify their insurance coverage, and in that situation, you might be able to make a recovery.
Okay, great. Thank you, Steve.
Thank you.
In the Name of Personal Injury Law is brought to you by the Sinas Dramis Law Firm. Go to WLAJ.com for more information on today's topics and to view other In the Name of the Law episodes. In the Name of Criminal Defense.
There have been several cases in the news lately involving the First Amendment. Criminal defense litigators Mary Chartier and Takura Nyamfukudza of Chartier and Nyamfukudza have had First Amendment defenses in their cases, and they're here today to talk about those cases and others. So the one I wanted to start with was a case involving Alex Jones, who claimed that the Sandy Hook shooting was false. Can you tell us about that case?
Certainly. Alex Jones hosts a show called InfoWars, and he was recently sued by victims of the families of the 2012 Sandy Hook Elementary School shooting, mass shooting. And they sued him for all the years that he spent spreading lies and making their lives hell. Ultimately, juries slapped Jones with substantial damages for all the years that he spent claiming, for example, that the Sandy Hook shooting was a big hoax. It was staged with actors, and all in all, he owes the families a total of $1.5 billion.
So were these criminal cases?
These were not criminal cases. The families primarily sued for defamation, which is that Alex Jones was lying because he repeatedly would say, as Takura mentioned, that this was not true, that this was a false flag, meaning a false event, even though there was absolutely no evidence of that. I mean, these were real children and real educational professionals who were murdered by someone with a gun. He had absolutely no evidence to back up his false claims. He tried to claim that he was just asking questions, but that's nonsense. And he tried to claim that he had the First Amendment right to make these statements on air to people to really rile up the people who listen to him. And he did not, because one of the exceptions for the First Amendment is defamation. You cannot say things that are false about someone. They can sue you for that. And they can sue you regardless of whether their damage is $1 or $1 billion. But in this case, a lot of the families had to move. There would be people coming to their home. There would be people who went to their child's gravesite and destroyed the gravesite because they believed that there wasn't a real child there. So if you can imagine these parents and families who sent their young child, this is an elementary school, sent their child to school, expected their child to come home that day, play, take a nap, have dinner, all the things that a family would do. Their children were murdered in such a horrific way. And then you have this very, very public and very vocal individual claiming that this is all a hoax and this is all a lie and that these parents are lying. And these parents were tortured for years by this. And they argued, you're defaming, right? Us. You are defaming our family, our child. What you're saying is a lie. And a jury agreed that this is a lie.
So was it a big verdict?
Huge. Again, that was billion with a B, right? And in the summer of 2022, his parent company, Free Speech Systems, sued for bankruptcy. And in Thanksgiving of the same year, Jones filed for personal bankruptcy. So he's trying to get out of paying the families a single cent.
No, there were a lot of allegations that he tried to move money around before the verdicts came in. So once he knew he was being sued, he was trying to, move money, hide money. And so there will be probably a big fight to try and find all the money that may have been moved around, put into other people's names. But this is, when we're seeing this more and more with what we're calling disinformation and misinformation going out. People lying about elections, people lying about all sorts of news events. And there are people who want to believe that because it fits with a certain maybe belief system or narrative that they have. But it really is important for people to try and get to the facts of what someone is claiming. I mean, I don't know about you, but, I mean, my family can't keep a secret, like if there's a party, if someone's trying to have a big secret birthday party, someone will find out about it. So to think that there would literally be thousands of people who are able to keep a secret about these murders, that they really didn't happen. I mean, it's a really ridiculous notion, but yet Alex Jones peddled it. And he also gets a lot of money from people who support him, gets a lot of money from individuals who donate to his groups.
So is Mr. Jones's show still on the air?
At last check, yes. As a matter of fact, the day after these verdicts came out, he was on the show with rapper Kanye West, who was talking about how much he likes Hitler, Adolf Hitler.
Okay, another Michigan case that involved, at least in part, people talking about actions involved Michigan's Governor Whitmer. Can you tell us about that case?
So in that case, a group of men, at least in the federal case, Mr. Croft and Mr. Fox, were alleged to be planning to kidnap Governor Whitmer, and the point of that was to inspire a U.S. civil war. But it turns out that there were several informants and FBI undercover agents who were involved the entire time.
So what were the defenses that they had for that criminal case?
There were a couple of defenses. In the federal trial, there was a trial of 4 individuals. 2 of the men were acquitted, meaning that the jury found them not guilty, and then there was a hung jury on the other 2. And then those individuals went to trial again, and then the jury found them guilty. Then there was also a state case with a few individuals. But primarily, the defense was twofold. Entrapment. There were government agents and informants who were being directed by the government who were kind of encouraging action. So the defense was, listen, these are just a bunch of talkers, people sitting around. You can say you don't like the government. You can say you don't like certain actions by the government. You wish harm would come to individuals. That's all protected by the First Amendment. It's when it kind of crosses that line into action. And the argument, again, was the words are protected by the First Amendment and the actions were encouraged by government agents.
So was their First Amendment defense successful?
So for a couple of the people in the federal case, it was. But the men who were prosecuted in Jackson County, and they were the ones who planned for Mr. Fox the firearms training in Jackson County. Unfortunately, those three were not successful, any of them.
So why were some of these men tried in federal court and others in state court?
So it's really going to be based on the complexity of the case and the actions of the individuals, or at least the actions that the federal government and the state government thinks that the people are taking. In federal court, U.S. attorneys frequently will say they want a particular case. So if it's a big drug case, even if it starts out in state court, and a lot of state court prosecutors will defer to the federal government and they'll allow the federal government to pick up the case. In federal court, the federal government has significantly more resources than state court prosecutors. The rules on discovery issues are much more burdensome for the defense in federal court. It is a better playing field for the government in federal court. And so they wanted to go after who they thought were the primary actors. It was not entirely successful for them. They had very, very vigorous defense on behalf of all four defendants, and two were successful, and the other two will be appealing. I mean, they've got a number of issues that they will be bringing forward.
And what were the sentences that the two that were convicted, what did they receive?
So for the gentlemen in federal court, federal prosecutors are seeking life. Okay. And for the Jackson County gentlemen, they received sentences of between, minimums of between 7 and 12 years. So ultimately, they'll have to apply for parole when those times come up, and the parole board would decide.
So really quickly, for the two that were acquitted in federal court, do they have any state charges that they're going to be filed against them?
Nope, they do not. And as you know, Lisa, we talk about these cases and so many more on our podcast, Constitutional Defenders. Thanks for having us.
Great to see you again, Takura and Mary.
Thank you.
In the Name of Criminal Defense is brought to you by Chartier Nyamfukudza, PLC.
Thank you for watching In the Name of the Law. We'll see you next week.
Thank you for joining us today for In the Name of the Law. Please go to WLAJ.com for more information on today's topics, and please join us next week for another informative show.